Hello everyone, this is Rishabh and you are watching Company360.in. Today we will be talking about foreign filing license in India. A foreign filing license refers FFL to a license issued by the Indian Patent Office for a patent applicant to file the patent application in a country foreign to India. This license is issued as per Section 39 of the Indian Patents Act 1970. Section 39 of the Patents Act states 39. Residents do not apply for patents outside India without prior permission. 1. No person resident in India shall, except under the authority of a written permit sought in the manner prescribed and granted by or on behalf of the controller, make or cause to be made any application outside India for the grant of a patent for an invention unless a. An application for the patent for the same invention has been made in India, not less than 6 weeks before the application outside India, and b. Either no direction have been given under subsection 1 of the Section 35 in relation to the application in India, or all such directions have been revoked. 2. The controller shall dispose of every such application within such period as may be prescribed, provided that if the invention is relevant for defense purpose or atomic energy, the controller shall not grant permit without the prior consent of the central government. 3. This section shall not apply in relation to an invention for which an application for protection has first been filed in a country outside India by a person resident outside India. As would be clear from the reading of the section, only when a resident of India who files or causes to be filed a patent application in a jurisdiction foreign to India without first filing said application in India, they are required to apply for FFL. Furthermore, the license is also required if an Indian resident filer wishes to file the application in a foreign jurisdiction before 6 weeks from the date of the first filing of the application in India. It may be noted that Section 39(3) of the Patents Act also explicitly exempts non-resident filers. It states that the section does not apply if an application for patent is filed in a foreign country by a person not residing in India. This means that residents of India who are planning to directly file or before expiry of 6 months from the date of Indian filing a patent application in a foreign country need to apply for an FFL. The form prescribed by the Indian Patent Office for this purpose is Form 25. Who shall apply for a foreign filing license? The reader may note that in practice, in a scenario where either the applicants or inventors are residents of India, it is preferable to obtain an FFL from the Indian Patent Office to avoid any challenges in the future. In this regard, one may refer to the wording of Section 39(1), which reads, "make or cause to be made," whereby in a case an applicant of the foreign patent is not an Indian resident, but the investors are, the clause may be interpreted to mean that the investors have caused the foreign application to be made. Furthermore, in a scenario where multiple applicants or investors are present, as per the present patent practice in India, an FFL should be obtained in case even one of the multiple applicants or multiple investors are Indian residents. It may be noted that in the view of lack of any judicial precedent on many such scenarios and the process of obtaining of FFL being streamlined and time-bound in India, it should be preferred to obtain an FFL before making any application in a foreign country. Provided below is a table containing scenarios of when an FFL should preferably be obtained in the present patent practice based on resident status of applicants and investors. If the applicant in the foreign country is Indian and the investor is also Indian, then FFL is required. If the applicant is Indian but the inventor is not Indian, then the FFL is also required. If the applicant is from foreign and the inventor is also from foreign, then FFL is not required. But if the applicant is from foreign and the inventor is Indian, then FFL is required. Who is a resident of India? In the pursuit of filing a patent application in different jurisdiction in a time-sensitive manner, the determination of whether an entity, legal or natural, is a resident of India becomes crucial. It is interesting to note that the Indian Patents Act is silent regarding this determination. In common parlance, in such scenarios, we have to refer to other legislations where the term is defined. In India, two acts which are referred in this regard are the Income Tax Act and the Foreign Exchange Maintenance Act. The provisions of these sections are discussed next. Section 6 of the Income Tax Act provides the definition of resident. An entity can therefore be determined to be a resident of India using the requirements of Section 6 of the Income Tax Act 1961 as the criteria. Specifically, Section 6 of the Income Tax Act states that a person or individual is said to be a resident of India if number 1. In the previous year, he has lived in India for more than or equal to 182 days in total. Number 2. He has lived for more than 365 days in India preceding the previous year in total and has lived in India in the past year for more than or equal to 60 days. A company is said to be a resident of India if number 1. It is an Indian company. Number 2. The company is managed from India or place of effective management is in India. Same as Section 6 of the Income Tax Act, Section 2V of the Foreign Exchange Maintenance Act FEMA 1999 also defines the resident of India. This section states that 5. Person resident in India means 1. A person residing in India for more than 182 days during the course of the preceding financial year but does not include A. A person who has gone out of India or who stays outside India in either case. A. For or on taking an employment outside India, or B. For carrying on outside India a business or vocation outside India, or C. For any other purpose in such circumstances as would indicate his or her intention to stay outside India for an uncertain period. B. If a person who has come to stay or stays in India in either case otherwise than A. For or on taking up employment in India, or B. For carrying on in India a business or vocation in India, or C. For any other purpose in such circumstances as would indicate his or her intention to stay in India for an uncertain period. As per this section, there are certain scenarios where a person working outside India is not a resident of India even though he has resided in India for equal to or more than 182 days in India in the previous year. But as per the Income Tax Act, the determination of the resident status is different. At present, there is no clarity as to which definition will have precedence to determine residency, even though usually reference is made to the definition under the Income Tax Act when dealing with residency status. The determination of whether an entity is a resident of India is a highly contested aspect of in India, even under tax laws, especially with individuals and entities having presence across nations. With the complexities of the patent law added to the mix, determinations pertaining to resident status of investors and applicants becomes even more tedious. Moreover, under Section 118 of the Indian Patents Act, if an applicant or inventor is not complained to Section 39, he or she is liable to be punished with an imprisonment term of 2 years or a fine, or both. Furthermore, non-compliance to Section 39 might also lead to any relevant Indian patent application filed in the name of the applicant or the inventor to be abandoned, or if the patent is granted, revoked. Hence, in cases of uncertainty, it is advisable generally to apply for an FFL should one believe that they may be determined as residents of India to avoid any penalties or difficult situations. Requirements in Form 25. Since it is imperative for entities to ensure applying for an FFL in scenarios defined under Section 39, the requirements for filing a request for FFL in Form 25 becomes extremely crucial. Broadly, the requirements related to Form 25 are: Number 1. Title and brief description of the invention. Number 2. The name and the address of the inventor or inventors or applicant or applicants. Number 3. The countries in which filing of the application is intended. Number 4. If the first filing is outside India, then the reason for doing so need to be specified. For example, lack of one reason may be lack of a market for the product in India. After receiving the application for FFL, the office and the controller are bound to dispose of an application within 21 days or 3 weeks as per Rule 71(1) of the Patents Rule. In practice, obtaining FFL is a straightforward and time-bound process if all documents and details are in order and the invention does not relate to defense or atomic energy. Want to get legal services for yourself? Company360.in provides you with all the necessities required for these procedures for a very reasonable price. If you still have some questions, feel free to put them down in the comments section. Or you can find us at www.company360.in or email us at info@company360.in, or you may even call us at 964-334-0938. Thanks everyone for listening. This was Rishav. Until next time.